everyone, and this is Kristen McCalla with Pepper Hamilton. Welcome to our webinar today. The webinar today is titled "The Clock is Ticking: What Employers Need to Know Now About DOL's New Overtime Rules." So thank you all for joining us. And before I turn it over to our moderator today, Matt DeLuca, I just wanted to go over a few housekeeping items. The audio today should stream automatically through your computer speakers. But if you're unable to stream your audio, please click the phone icon that I have highlighted here, and a phone number will be sent to you. We also encourage you to send us questions throughout the program today by clicking the Q&A button at the top and then typing your question down at the bottom. You also can download a copy of the PowerPoint slides today by clicking the file and saving it as a PDF type. And with that, I'll turn it over to our moderator today, Matt DeLuca, who is a partner and chair of our labor and employment practice.
Good morning, everybody, and thank you for participating. My name is Matt DelDuca, and I'm the chair of Pepper's labor and employment practice. And I'm privileged to have today with me our crack wage and hour FLSA and state wage and hour team. We have a group of people here that have dedicated a lot of time and effort into understanding and developing strategies on the wage and hour laws, and who have focused their practice in litigation also on wage and hour matters, which, as we'll discuss in a little while, have been proliferating, particularly over the last 10 years or so. So first, I'll introduce Susan Lessig. Susan concentrates her practice on advising and litigating, but primarily advising employers on many matters, most importantly, wage and hour matters. She also conducts audits and investigations for employers to ensure compliance and to help employers develop the strategies to deal with the problems they face today. Also with me is Chris Moran. And Chris Moran is really one of the leading wage and hour experts in our region. Chris handles complex wage and hour class actions and other collective actions and other litigation, and advises clients on wage and hour matters. And last but not least is Lee Tankel. Lee's this newest member of our wage and hour team, and Lee did a tremendous job putting together the slides today and helping us prepare for this webinar. And Lee has devoted a lot of time to understanding the wage and hour law, and in particular, really understanding the new regulations in and out. And so we're happy to have Lee with us today. So with that, I think we'll get started. We're here today because new regulations were implemented by or published by the Department of Labor on May 17th. Those regulations become effective on December 1st, 2016, and today we have a beautiful, probably our first beautiful summer-like day, and December 1st seems like a long way off, but it's not very far off, and there's a lot of work to do because these new regulations will impact overtime exemptions for a very large number of employers, if not all. Nearly all employers will be impacted by these changes. The Department of Labor has issued some statistics that over 4.2 million employees will be affected by the new regulations. That is, employees who fit in the sweet spot between what was the minimum salary requirement and what the new minimum salary requirement is. So it's a huge number. And these changes come at a time when compensation is a major topic. It's a major topic in the political spectrum, both at the presidential level, but also at the state level. Many states have enacted or are considering significant increases in minimum wage. We've seen an increase a gradual but increase to $15 in California. New Jersey is considering the same, as are a number of other states. Some states, in fact, many states, have enacted special rules for overtime exemptions. California and New York are among a large group that have rules that are different than the federal rules. And at the same time, all of these things are happening at a time when wage and hour litigation is by far at its highest point, certainly in the 30 years that I've been practicing law. And really in the last 10 years is when, 10 or 15 years, I guess you could say, is when litigation has just exploded in the wage and hour field. It started on the West Coast and then for some reason became very active in Florida, but it is everywhere now, and certainly we're seeing huge increases in wage and hour litigation on the East Coast in New Jersey, Pennsylvania, New York, and Delaware, and the surrounding states. And we have some statistics here, and I'm not sure these statistics even tell the story because these are statistics for federal wage and hour matters. We also have seen a huge amount of state wage and hour matters. As I mentioned, many states have different rules, most of which are more favorable to employees, and plaintiffs' lawyers will utilize those special rules in different states to bring state actions that aren't captured by these statistics. And I think we can be sure that the new regulations and the changes that so many employers are going to be forced to make over the next 6 months or so are going to spur even more litigation. Certainly there's going to spur a lot of scrutiny from plaintiffs' lawyers over what employers are doing in their wage and hour practices. So today, our goal is to, number one, inform you about the substance of the new overtime rules, what they require, and what existing rules are being significantly changed. And then we want to turn to the strategies that employers can use to manage these changes and to implement new rules, because there are a lot of decisions that have to be made, a lot of employees are impacted, and there are a lot of options that employers have about how to handle those changes. And then finally, we'll spend a few minutes talking about the strategies or the methods that Pepper uses to try to help our clients navigate this changing landscape and to deal not only with these changes, but to review wage and hour practices generally and to advise about whether some changes in areas not affected by the new regulations ought to be made, whether this is an opportune time to make some additional changes. So with that, I want to turn to Susan Lessig to start the discussion about the substance of the changes made by the new regulations. Susan?
Good morning, everyone. As you probably know, there are several categories of jobs that are exempt from the overtime requirements under the Fair Labor Standards Act, and employees who fall within those categories do not have to be paid overtime if they work over 40 hours in a week. These new rules affect only the 3 what are called white-collar exemptions, and those exemptions include executive, administrative, and professional. And the white-collar exemptions capture most employees who are classified as exempt. So these new rules will have a substantial effect on the number of exempt employees that will exist. To qualify for a white-collar exemption, employees have to be paid a minimum weekly salary. With some exceptions, they regularly receive the same amount of compensation each pay period, regardless of how many hours they work, and they must meet what's called the duties test. Each of the exemptions, the administrative, the executive, and the professional, have different requirements that an employee holding a particular job has to satisfy in order to be exempt. And the duties test looks at whether the employee's primary duties meet the specific requirements of a particular exemption. These new regulations affect only the first factor, whether the employee is paid a minimum weekly salary. There are a number of other exemptions that exist under the Fair Labor Standards Act which are not affected by the new regulations. They include the exemption for outside sales employees, which does not require that an employee be paid a minimum salary either before the new regulations or after. And also the commissioned retail sales employees exemption is not changed by these new regulations. So what is the new minimum salary threshold? Currently, until the new regulations take effect, the minimum salary threshold is $455 per week, or $23,660 per year. That level has not changed at all since 2004, and it is generally recognized as outdated. So the Department of Labor, with the new regulations, has more than doubled the minimum salary threshold to $913 per week, or $47,476 per year. The new salary threshold is pegged at the 40th percentile of weekly earnings for full-time salaried employees in the lowest income census rate region, and that's currently the South. As a result of this increase, 35% of full-time salaried employees will now be eligible for overtime. The Department of Labor has explained that increasing the minimum salary threshold to this amount will make it easier for employers to determine if employees are exempt. Because if an employee earns less than the $913 per week, the employee will not be exempt even if he or she meets the duties test. The Department of Labor, to avoid the problem that has existed with the salary threshold not having changed since 2004, has included a provision pursuant to which the minimum salary requirement will automatically update every 3 years. And the same calculation will be used as we've used to come up with the current threshold, that is looking at the 40th percentile of the lowest income census region. So the new rules, as Matt said, will go into effect December 1 of this year, and the first automatic increase will take place on January 1 of 2020 and every 3 years thereafter. As I mentioned, the new rules affect only the minimum salary requirement for being exempt under the white-collar exemption. There is no change to the duties test, despite a lot of discussion and some trepidation on the part of employers as to whether that test would be changed. When the Department of Labor released its proposed rule, it asked for comments as to whether the duties test should be changed. And among other things, the Department of Labor asked whether the primary duty that's required for each of the exemptions should be further defined, such as whether an employee needs to spend a particular amount of time performing that primary duty in order to satisfy the duties test. After considering hundreds of thousands of comments on that and other issues, the Department of Labor decided to leave the duties test alone. And so even though the duties test isn't changing, the courts and the Department of Labor will continue to strictly construe the exemptions, and it remains important, as you'll hear later, to make sure that employees are classified correctly. With that, I'm going to turn it over to Lee, who will discuss some of the other changes in the new rules.
Thank you, Susan, and good morning, everybody. Under these new rules, for the first time, employers are going to be able to use non-discretionary bonuses and incentive payments, including commissions, to satisfy up to 10% of the new minimum salary threshold that Susan was talking about. So what does that mean? for example, you have an exempt employee out there who otherwise meets the duties test, but currently makes a base salary of, let's say, $45,000 a year. Because that's under the $47,000 number, that person is not going to be considered exempt under the revised regulations. But if that same employee makes $3,000 extra in commission or non-discretionary bonuses in the year, that person will then fall into exempt status because those $3,000 can be used to get you over the minimum salary threshold of $47,476. While employers can certainly give a larger bonus, you'll only be able to put 10% of that up to the new minimum salary threshold. So that number is $4,747.60. You can't have a situation where an employee is making $25,000 a year and then give them a $25,000 non-discretionary bonus at the end of the year until classified under exempt. So in order to take advantage of these new rules, you need to make sure that bonus payments are made on a quarterly basis, or on at least a quarterly basis. That means every 13 weeks. Now, there are provisions within the new law that allow you to make catch-up payments. For example, if an employee is expected to earn a certain commission in a quarter, if the employee doesn't earn enough in that particular quarter, doesn't earn that bonus, doesn't earn the incentive payment that he or she was expected, he or she can be given a catch-up payment within one pay period to make up for that shortfall. So in practice, under these new rules, in order to be exempt, you need to be making 1/4 of $47,476 in a quarter. That means $11,869 per quarter. So if an employee who earns commissions or non-discretionary bonuses reaches the end of the quarter and hasn't reached that number, an employer has two options. They can simply go back and pay the employee overtime pay for any overtime hours they worked during that quarter, or they can pay the employee an additional amount in the next pay period to make up for the shortfall. So if you have somebody who was $900 short of what they would need in order to be exempt, the employee can make a $900 payment and keep the exemption. So some of you may be asking yourselves, like, Lee, why do you keep using the word non-discretionary bonuses when we're talking about this? What does it mean? Well, it's important to realize that you can only use non-discretionary bonuses to meet 10% of the current threshold. I'm going to talk to you about what a discretionary bonus is and what a non-discretionary bonus is. And in a little bit, Matt's going to talk to you about why it's so important to differentiate between the two. So, as I said, only certain non-discretionary bonuses and incentive payments count towards this 10% number. Non-discretionary being the key. The Department of Labor cites as examples of non-discretionary bonuses and incentive payments as payments that are forms of compensation promised to employees to induce them to work more efficiently or to remain with the company. Some examples include attendance bonuses, bonuses for meeting set production goals, retention bonuses, and commission payments based on a fixed formula. For example, if you produce 100 widgets a day, you'll be given a $50 bonus. That's an example of a non-discretionary bonus. Or you'll be entitled to 1% of all revenue for the products you sell. And non-discretionary bonuses can also include pre-announced bonuses, which are tied to employer profits. Discretionary bonuses don't count. A discretionary bonus is what it sounds like. It's purely discretionary. It means the decision to award the bonus and the payment amount is at the employer's sole discretion and not in accordance with any pre-announced standards. It includes spontaneous rewards for a specific act, and it also includes unannounced bonuses, situations where perhaps the company had a very unexpected, very profitable year, and the employer decides to give employees a bonus based on how hard they believe the employee worked that year. You can give these types of bonuses, but you're not going to be able to count that towards the 10% that gets you to the minimum salary threshold of $47,476. So, while less publicized than the changes Susan discussed earlier, there are also going to be major changes to the Highly Compensated Employee Exemption. Truth be told, this is not a very common exemption, and not one that we see people use too often. But under the exemption, an employee is deemed exempt from the minimum wage and overtime requirements if she meets a minimum annual salary threshold, has a primary duty of performing office or non-manual work, and customarily and regularly performs at least one of the exempt duties or responsibilities of an exempt executive, administrative, or professional employee. So this exemption is kind of a catch-all for individuals who make a significant amount of money but do not necessarily fall neatly into the strict executive, administrative, or professional employee categories under the duties test. The big change here to this exemption is what that minimum annual compensation is. It has been since 2004 $100,000 per year, but starting December 1st, that will increase to $134,004 per year. And as long as the employee meets the test I just mentioned, makes $134,004 per year, and makes at least $913 per week, they can fall into that exemption. Where did this $134,000 come from? It's equivalent to the 90th percentile of earnings for full-time salaried workers nationwide. Like the other salary thresholds, this number will also rise automatically every 3 years, starting on January 1st, 2020, and changing every 3 years thereafter. And that 10% bonus threshold that I just mentioned doesn't apply directly to this highly compensated employee exemption. To reach $134,000, you can rely on commissions, non-discretionary bonuses, and other non-discretionary payments, as long as you're still ensuring that employee is making $9 to $13 weekly. Matt?
Thanks, Lee. And just one final point on the highly compensated employee exemption. There is a different catch-up provision for that exemption, where a catch-up payment can be made actually at the end of the year, or within, I think, one pay period at the end of the year. So if the employee doesn't meet the $134,004 salary requirement up to the end of the year, if you want to maintain that employee as exempt, you can pay them the difference at the end of the year to make sure that they have met it. It also gives a lot of flexibility in terms of commission and bonus payments to employees. But again, if at the end of the year, the employee has not earned commissions and bonuses coming anywhere close to the number, and the employer really doesn't want to make that employee exempt, the employer has that option, but then you're going to have to undergo the difficult task of going back and figuring out how many overtime hours that employee worked and paying time and a half, et cetera. So anyway, the highly compensated employee exemption has some different analyses than the primary exemptions that we've been talking about, that we call the white-collar exemptions. So collectively, the question is, what do these rules mean for employers, and what should we be doing? What's the basic takeaway? So the first is that in general, exempt employees who are currently making an annualized salary of less than $47,476 a year, or $913 a month, $913 a week, will either have to be given a raise to meet that requirement or converted to non-exempt. And obviously, if they're converted to non-exempt, that means, number one, the employer has to maintain accurate records of the hours worked and pay at least 1.5 times the hourly rate for all hours worked in excess of 40 hours. A major change is going to come to those employees in that, what I call the sweet spot between the old minimum salary and the new minimum salary. So that's the first difficult question employers are going to have to answer. The second is that employers are going to need to coordinate their bonus and commission systems with the decision that you make in terms of classifying those employees. And as we'll discuss in a little while, that can have a huge impact as well, because there's not exact symmetry in terms of how these bonuses and commissions are treated for exempt and non-exempt employees. And then finally, employers should be considering reevaluating not only the affected exempt positions, but other exempt positions as well, and looking back at whether or not there are exempt positions or positions you're treating as exempt and that are question marks about whether you want to continue to treat them as exempt. This is an opportune time to to make changes across the board that hopefully would, otherwise might raise some concerns or be a target for potential litigation. So those are the major takeaways. Next, I want to turn to some of the strategies that we can use to make all of those decisions in a way that matches up best with what each employer needs and wants to achieve. And I'm going to turn to Chris for that.
Thanks, Matt. So what factors do you consider when you're deciding what you're going to do with someone who no longer meets the exemption? Obviously, one of the most important ones that you consider is cost. So if you're going to convert someone from salaried to hourly, what's the math involved with that? How do you do it? When we figure out what I would call a nominal hourly rate for a salaried employee, we typically do that by dividing by 2,080, that being the 40 hours a week times 52 weeks a year. And that does give you an hourly rate, but it doesn't work real well to use that hourly rate if it's an employee who works more than 40 hours on a regular basis. So in the example on the page there, with an employee who works an extra 5 hours a week, if you use that kind of an analysis, the employee ends up with something along the lines of a 20% raise in total annual compensation. It is possible to adjust for it, and in a recent situation where IBM lost a piece of litigation involving classification of some of its employees, and it decided to reclassify others, it decreased the compensation for those folks by 15% in order to account for what they would then get in overtime, so that they'd break even, hopefully, at the end of the year. In the example on the page, you'd have to decrease the person's hourly rate by several dollars an hour, and of course that raises another consideration, which is a hit on morale, if that is the approach you take. Another question that you consider when deciding how to best handle the situation is variability of the weekly compensation. So some of the employees, particularly those perhaps who are on the lower end of the salary threshold now, so those making $24,000, $25,000, $26,000 a year, they're living perhaps week to week. And if they're converted to hourly, and if their hours vary, then that can cause their compensation from week to week to be thrown off. So you want to consider the impact on them. A big factor, and we've seen this in several situations, is the impact on morale. Although we may complain that we work a lot of hours and we don't get paid overtime, by and large, employees prefer to be salaried employees. They prefer that it's prestigious. They consider it a promotion when they get their first salaried position. And telling them now that you're going to change them back to hourly can cause significant morale problems. One possible way to deal with this, which we want to mention here, but we've also mentioned it's not available in Pennsylvania, would be the fluctuating work week method. In some states, and this is another instance where we would take the opportunity to remind you that in wage and hour cases and wage and hour situations, you have to always consider not only federal but also state law. And Pennsylvania law does not line up exactly with federal law, and this is one of those instances. But under federal law, there is a concept recognized as a fluctuating work week. In the fluctuating work week situation, you can agree with the employee that they will get a flat dollar amount that will compensate them for all the straight time hours that they work a week, and then they get essentially half time for any hours they work over 40 in that week. It does involve a little bit of a calculation, and the DOL has indicated a strong dislike for it, but it is still available under the regulations. If you're dealing with an employee who was previously covered under the Highly Compensated Employee Exemption, and we had this situation within the last few weeks, well, how do you approach that? Well, if they're making $100,000 a year at present, then perhaps they're doing something important that will allow you to put them under one of the other exemptions. Are they managing 2 or more employees? Can you take a look at that? Might they qualify for the executive exemption? Are they exercising independent discretion and judgment with respect to significant matters? If so, might you be able to qualify them under the administrative exemption? If not, are there employees that you can put underneath them that would allow them to then supervise 2 or more employees? Can you reassign duties or people to them such that they would be exempt? And of course, I think, as Matt mentioned, if you're short at the end of the year with respect to the highly compensated employee, you can make that up with a bonus payment. Matt?
I want to talk a little bit more about the impact of bonuses and commissions on compliance. So as Lee mentioned, bonuses and commissions and certain other incentive payments can be counted toward the minimum salary requirement for exempt employees in order to meet the salary threshold, but only 10%. In addition, we do have a catch-up provision that is at the end of essentially each quarter. Catch-up payments can be made if the employee hasn't earned those bonuses and commissions in order to meet the minimum requirement. So that's the new set of rules that's in place now when it comes to meeting the salary requirement for exemptions. Before, bonuses and commissions couldn't be counted at all. And in a second, I'm going to talk a little bit about how bonuses work with and commissions work with non-exempt, that is hourly employees. But no matter what, whether employees are exempt or non-exempt, and they're receiving bonuses and commissions, if they are non-discretionary, it's very important, and even if they're discretionary, very, very important to have a clearly articulated commission and bonus plan or policy. It's also very important in light of the changes to make sure that that policy is coordinated with your overall strategy in dealing with the changes for these employees. And there's some options. We have some tools to work with, such as the catch-up clause. There are some options in terms of potentially using rolling commission periods with minimums and some other options. But not only is it important to have a clear policy on what the rules are about earning bonuses and commissions, it's also very important to implement that policy accurately and consistently, because you can have a great policy, but if you don't apply it accurately and you, as a result, are underpaying someone or a group of people, then those people can be treated as non-exempt and you go back for the entire period of the variance. It also makes it for very difficult proof issues in litigation when you have great policy, but it's not actually applied in the real world, and employees can show that, and then as the employer, you're stuck with a situation where you may not, for instance, have very good records on how many hours these employees have worked, and those of us here and anywhere who have handled class actions and collective employment actions involving wage and hour know that somehow the employees who bring those actions when there's poor records of how many hours they've worked magically seem to have worked 20 and 30 and 40 hours of overtime per week on average, at least that's what they allege, because the burden's on the employer then to establish the hours worked, always on the employer to establish the hours worked. And if you don't have the records, then you're at the whim of what the employees allege, and it becomes pretty difficult to prove to the contrary. So I want to juxtapose against how bonuses and commissions are treated in the exempt world from how they're treated in the non-exempt world. So if non-discretionary bonuses for non-exempt, so for hourly employees, must be included in the regular rate and factored into the overtime rate. And this could be complicated. So if an employee earns a commission, let's say over the span of a month, and they're getting paid a minimum payment, let's say $10 an hour plus commissions, and at the end of the month they earn a commission, and let's say they've worked 10 hours of overtime a week, well, it's easy. As you're going along, they get paid $15 an hour for those 10 overtime hours. But then at the end of the month, if they receive a commission, you have to recalculate the overtime, the regular rate and the overtime rate, taking into account the commissions that were earned. And you have to do that for the period over which those commissions are earned, which is not defined in the regulations before or after the changes. So a key issue becomes over what period the commission was earned. And the bad news is that that's often unclear. The good news is the employer's policy or plan can state, it's up to the employer to state over what period those commissions or bonuses are earned. So it's really in the hands of the employer to do that. And it's essential that your policies establish that because otherwise it can be very unclear. And it can make a big difference in terms of what overtime is earned by that employee. And this issue of including bonuses and commissions in the overtime rate has been a favorite target of plaintiffs' employment lawyers. A lot of employers do this wrong. It's complicated to do. A lot of employers don't have very good policies that can help them to do this correctly. And so plaintiffs' employment lawyers love this topic. And so, if you are paying non-exempt employees bonuses, you want to make sure, and commissions, you want to make sure that you're doing this right. Interestingly, purely discretionary bonuses do not count against the regular rate or the overtime rate. So when it comes to non-exempt employees, there's an incentive for employers to treat bonuses and commissions as discretionary. That is, the decision whether to give a bonus or commission is discretionary, and the amount is discretionary. And if that's the case, if you meet the definition of discretionary, then you don't have to do they don't count toward the regular rate, they don't count toward the overtime rate. And so you can see that the incentive for dealing with discretionary bonus is very different for non-exempt versus exempt. Because with exempt employees, that purely discretionary bonus doesn't count toward meeting the minimum requirement. Okay. So especially for employees who receive sort of a minimum payment per week in order to meet the minimum wage requirement and then get paid commissions periodically, this retroactive payment when they're non-exempt can result in huge overtime obligations. So just taking an employee who gets a $10 an hour payment plus commissions, if that employee gets, let's say, a $25,000 commission one month and it's earned over 4 weeks, and that employee worked 10 hours of overtime per week, in addition to the $25,000 in commission, the employer, it's complicated math, but once you do it, that employee would be entitled to an additional $9,000 in overtime pay for that month, over and above the $25,000. Most employers aren't factoring that in when they're trying to figure out what to pay employees in commission, and you need to do that. So really essential to have the bonus and incentive and commission plans coordinated with your exemption status. Just another couple of words on bonuses and commissions for highly compensated employees, and we touched on this a little bit earlier. So with highly compensated employees, bonuses and commissions can apply without that 10% minimum in order to meet or 10% maximum in order to meet the minimum requirement. So with highly compensated employees, as long as they get paid $913 a week, you can make up the difference over the year in commissions and bonuses and still meet the minimum threshold, which is going up to $134,004. And in addition, you have the additional bonus here that with highly compensated employees, you can do a catch-up at the end of the year as opposed to quarterly, and that gives the employer a lot of flexibility. All right. So Next, I think we want to turn to the topic of in implementing strategies of dealing with the new regulations, what employers ought to be thinking about in terms of reevaluating or evaluating the existing exempt employees and whether any changes ought to be made around the same time. Chris?
Thanks, Matt. Just to follow up on one thing that Matt said, when we're talking about using or about paying bonuses to non-exempt employees and excluding them from the regular rate because they're discretionary, please keep in mind that the DOL's interpretation of what is discretionary is likely going to differ from yours and from common sense. So if you are paying a bonus to the employee on a recurring basis, for instance, the DOL is likely to conclude that although you claim that it's discretionary, it may very well not be. With respect to reevaluating exempt employees, if there is a silver lining in the new rules, there's probably two, right? So they didn't revamp the duties test, which is I think probably a positive. The other is this is a window for going in, taking a look at what we're doing, and correcting. Whenever we talk to an employer and do an audit of the positions, and we find positions that are misclassified and we have to deal with how to fix them, there's always, the big question after that is, well, are we going to pay retroactive pay? If we're going to pay retroactive pay, do we do it under, do we go back 2 years? Do we go back 3 years? How much is it? Can we calculate it? And that's very costly and very problematic. If there are problems in classification right now, this is a great opportunity to look at all the classifications, see if they meet the tests, properly meet the tests, and if they don't, take the opportunity to convert them over. Right now, with all that's going on, with all the publicity that these new rules are getting, it's much less likely that they're going to draw scrutiny. It's much less likely that an employee is going to run off to a plaintiff's lawyer and then sue you and seek 3 years of back overtime for the, on the basis that I was always entitled to be paid on an hourly basis and you owe me overtime. So take advantage of this opportunity to sort of clean up our act. And then we'd like to sort of give you some takeaways. So our takeaways for preparing for the effective date of the new rules. First one would be what we just touched on, audit at least any of your exempt positions making less than the new salary thresholds. It'd be a good time to audit all of them, but audit at least the ones that are now going to fail the tests. With respect to each of those positions, identify any options that you have. Can you reclassify them, as hourly? Are you going to be able to control their hours if you do that? Are you going to be able to limit their working overtime? Can you fit them under a different exemption? Can you fit them under an exemption? There are a handful of exemptions, depending on your state again, keep the states in mind, that don't have a salary threshold. So figure out what the options are for each one. Evaluate the cost impact on the organization of the options, the morale hit on the employees of the options, and other relevant factors, and select the ones that you think are best. Then develop a communications plan. How are you going to roll this out? Who are you going to tell and when are you going to tell them, and how are you going to spin it, and how are you going to present it? If you're converting significant numbers of employees to hourly, you may want to consider whether you want to implement a policy to keep a check to control the overtime. Keep in mind that if employees work overtime despite our policy, we have to pay them, and the proper way to deal with them is discipline. But it's perfectly acceptable to have a policy that says they're not supposed to work overtime or they can't work overtime without authorization. But if they do work overtime, the proper way to deal with it is pay and discipline. Also ensure that you're ready from a sort of a paperwork perspective. Make sure that you are keeping proper records so that you'll be able to track hours for anybody you now need to track hours for, and that you have the records if you ever get audited or sued. Train supervisors. If this is new to them, or if they're going to be supervising new groups of hourly employees, make sure that they understand. Then implement, and then monitor it. Keep an eye on it. Go back and look at it as it's going on, and look at it a month and 2 months and 3 months later. Is it working out? Are you now compliant? How's the cost? Has it increased about what you thought or significantly more? What's the impact on operations? And reevaluate as you go on an ongoing basis. Matt, back to you.
Thanks, Chris. Just to follow up on a couple of the things that Chris said, focusing on monitoring and continuously evaluating the impact that this has on employers, those are two really important things, because as I mentioned earlier, having making a decision now, making a policy, having everything nice and tidy at this point is great and necessary, but then making sure it's actually applied as written and as the decision was made is essential, because so much can be undone in the vagaries of the real-world application of these policies, and you really need to make sure that they're being applied appropriately, and that managers aren't, in some cases, undoing all of the good that's done by the changes in your practices in a way that really exposes you to additional compensation. And I've had cases where that has happened, and employers have paid a huge price for that type of situation. Really, really important. And the other is, this is a moving target. As Susan mentioned, the minimum salaries are going to go up in 3 years, and they're going to go up periodically after that. And it's really important to keep up with that. You'd be amazed. We have a similar situation. California has its own set of rules, and in California, the minimum requirement is pegged to 2 times the minimum wage. And so as the minimum wage goes up, there are lots of employers in California that forget to make the change to the minimum salary for their exemptions, and they have groups of employees who are now no longer exempt because that small changes weren't made in order to keep up. And this is something where you're going to need to keep up. We had, I think both Lee and Susan mentioned that the minimum salary requirements were last changed in 2004, and those changes were small. Nothing like this. They were small changes. The numbers that are the minimum salary requirements that are now being changed have basically been in effect for something like 20 plus years, and so employers have not had to keep an eye on that. You're going to need to keep an eye on that going forward, and frankly probably continue to evaluate whether or not at these other levels, these higher levels that are going to be applied later, whether it still makes sense to have these employees as exempt. So, and then the last thing, and this is a segue into what Pepper can do. Now, obviously, we have a team that's dedicated to evaluating these matters, a team that's dedicated to keeping up on every change in the regulations and in how the law and the regulations are being interpreted by the courts. I think Chris mentioned when it came to the definition of discretionary bonus, that what a common sense definition is not going to be consistent with the definition in the regulations, and that the DOL would insist upon. And I think, I've been practicing, as I said, for 30 years, and I think probably more than in any other area of practice of employment law, logic will fail you if you are trying to just apply logic in deciding what the rule probably is or is likely to be, or what the outcome is likely to be. We get a lot of very illogical and in some cases very unfair results in this area of law. So it's really important that you are fully informed about the risks when you're making these decisions about what to do. And it's also very important to have that done, if you can, in a privileged way. So, obviously, if you're using legal counsel, whether it's Pepper or another firm, to help you analyze these positions and to make decisions, you have the benefit of the attorney-client privilege, and it's valuable, because if you don't have the benefit of that privilege and you're in litigation later, then you could be, all of that communication could be exposed, and some of these risk-benefit analyses that are being done don't look very good in the litigation context. So, we're well positioned, and we have a dedicated group to do that here and to do the analysis of the job duties and compensation system, and identify options for you, and so that you can make decisions on exempt versus non-exempt status, so that you can evaluate your pay policies, coordinate them with your bonus and commission plans, and have a coordinated strategy for dealing with these issues. And we try to do that in a way, we know that our clients want to comply with the law, they want to do this right. They also want to have some predictability in terms of what it's going to cost them to get there. And so we work hard to try to provide that to our clients. And we have we have some very creative fee arrangements. And in this area, we're able to use flat fees to say, all right, this is what it will cost you to do this analysis. Now, it's not the same flat fee across the board for every client. We would get information from the client about the number of positions and give you fees either for a particular piece of work or different areas, some options in things you do. For instance, whether or not you want to review existing exemptions. So, and we have found that clients appreciate the fact that they have the predictability of flat fees and some other fee arrangements that we do that are different than just the typical hourly rate. In the end, you all have to balance the cost of getting this done, getting it done right. And if you can do that, and you can do it economically, there are tremendous savings to be had. As I mentioned earlier, wage and hour practices are a primary target of plaintiffs' lawyers, and the amount of litigation is massive. And how well you've done this job is going to affect what type of litigation target you are. And I guess one of the things that is the most difficult to quantify on a bottom line anywhere is the savings that you've had in not getting sued because you weren't that target, because your policies were good, because the decisions you made were well done. None of us can really know about the litigation avoided. And in the end, you only know it because of going over periods of time and not having that type of litigation. And but the value is there, and I think that the investment in getting these changes made effectively will bring great returns. With that, we're open to questions. Oh, we have some questions. All right, great. So let me read this one and open it up to the panel. Can you explain how to do the analysis to decide whether you fall under one of the three exemptions? What does this administrative mean exactly? And explain also the difference between the two exemptions, highly versus not. What are the differences other than pay? I'm not understanding the difference between the two exemptions. Can you give us an example? Okay. Susan, you want to take that?
I can do the first part. So, as I mentioned, there are the three different white-collar exemptions: professional, administrative, and executive, and they all have their own tests. For the professional exemption, an employee, and these are in addition to the minimum salary threshold test that we talked about. For the professional exemption, the employee has to have a primary duty of performing work that requires advanced knowledge in a field of science or learning. And that usually means having a degree in that field. So, for example, a psychologist typically requires a degree in psychology to practice in that area. There's also a creative professional exemption that applies less frequently, but that involves a job that requires talent, imagination, etc., in a field of artistic or creative endeavor. The administrative exemption involves an employee whose primary duty is to perform what's called office or non-manual work. So that's distinguished from production work. So is your job to produce the product that the company is in business to produce? Is it to produce the services that the company provides? Or is it more of an office position, a staff position that exists to assist in the production services of the company? In addition, for the administrative exemption to apply, your job has to be related directly to the general business operations of the employer or its customers. Probably the most significant piece of the administrative test is that the employee's primary duty has to involve discretion and independent judgment. So, for example, human resources managers typically fit into this exemption. If their jobs involve, for example, making recommendations as to whether an employee should be terminated. Even if that recommendation might be overturned by senior management, the human resources manager has the discretion to make that recommendation and consider all the relevant factors. In contrast, a human resources assistant or coordinator whose job involves processing payroll and that sort of thing would not meet the administrative exemption because that person is not exercising discretion. So just think about the distinction between someone who has set guidelines and it applies and follows that guideline versus someone who can decide every day how to carry out the functions of their position. And finally, the executive exemption, as someone said, involves directing at least 2 or more employees. So that refers to managers who have hire fire authority and also authority as to other employment decisions. Again, even if their recommendation can be overturned by upper management, they have the authority to make those recommendations. And perhaps Lee can address the distinction of highly compensated employees versus other exempted.
Actually, I was going to do that, and just that's okay. And then just following up on what Susan said, as you can tell from her answer, it's a complicated question. So each of these exemptions has very technical requirements, and you have to meet the requirements. And you know, we spend a lot of time when we look at positions, you're evaluating each of the requirements. In some case, it's an either-or for part of the test. And so very technical analysis has to be done for positions to determine whether or not they qualify for one of these exemptions. And sometimes positions that, in a common sense way, you might think are probably going to meet one exemption, but based on the name don't, but they do meet another exemption. So it is not something you can do, you know, a lot, you know, just trying to analyze without doing a deep analysis of each particular requirement and determining whether you meet it. And these exemptions have been in place a long time. The language has been in place a long time. And there are lots of cases that deal with the fine lines between these. And there's a lot of positions that it's a tough call on whether or not they meet. And we find that on a lot of those positions, there has been litigation over the years that's developed that really helps us decide whether or not a position is or isn't or exempt, or whether, you know, there's some risk involved in treating it as exempt, so that we can advise on that. It's a difficult analysis for someone to do who isn't very experienced in this type of work. That's just, I think, a takeaway that I would make. Now, on the highly compensated versus not highly compensated, so that the highly compensated exemption, again, is one that's pretty rarely applied, but it applies when employees don't meet one of the other 3 exemptions, professional, executive, or administrative. But they meet some of the requirements, but not all of the requirements of any of those. This is sort of a catch-all for employees who don't otherwise meet an exemption and are paid a high amount of money. It used to be $100,000, now it's gone up to $134,004. So I think in most cases you're not going to be considering the highly compensated analysis, and if there's a question about that, you'd probably want some advice about whether that employee can properly fall into administrative, executive, or professional, so that you don't have to pay them $134,000 more with this new change. So that's an analysis I think you'd probably want to do.
Okay, Matt, we have another question. Does the minimum pay threshold apply to teachers? And the answer to that is no. Under federal law, if the primary duty is teaching, tutoring, instructing, or lecturing, and teachers include professors, adjunct instructors, teachers of skilled and semi-skilled trades and occupations, and in certain instances they may also include coaches, but you have to sort of be careful about that. And you also have to be sensitive, again, this is federal, we're talking about the FLSA, you always have to be cautious, aware of state law as well. We have another one here that I'll touch on and then I'll ask Lee to answer a few, which is what about recurring holiday bonuses? Recurring holiday bonuses are the kind of thing that the DOL has in certain cases taken the position are not discretionary. If they continue to be given year after year and the employees expect them, the DOL may take the position that they are not discretionary.
All right. We have a few more questions here. For companies that do semi-monthly payrolls instead of every 2 weeks, how does the $913 per week change? For example, can we calculate a monthly salary requirement, or do we have to make an additional calculation? A work week is defined as a 7-day period. So as long as somebody's making $913 over 7 days, or double that, $1,826 over 14 days, you should be in the clear. One thing to note, though, a lot of states do have laws about how often an employee needs to be paid. That's not controlled by federal law. Some other questions we have here. How will this impact part-time employees? Say someone who is working on a schedule of 20 hours per week, will overtime pay start at 20 hours or 40 hours? Under the law, there's no requirement to pay overtime unless an employee has worked more than 40 hours in a work week. We have a few other questions out there as well. Here, so
that may be it. There's one question here. Most employers don't require exempt employees to punch in and out at the present time because they're salaried. Now, I'm assuming that they would be urged to change that policy to have exempt employees punch in and out. It depends, I guess. Certainly, if you have a group of employees where it's questionable, you may want to make sure that they do that so that you can track it, so that you can defend against any litigation. If you're fairly confident that they are properly classified as exempt, it's probably not as important to do that. If you're considering how to address these new regulations, this is the perfect time, though, to track hours. Get an accurate read. If your business isn't too seasonal, get an accurate read over the next 6 months as to how much, or next 5 months, of how much overtime do they actually work. And that may help you when you're costing out what option you're going to choose to deal with the new regulations.
Looks like we have more questions coming in.
If an employee receives a different stream of income, one from a boss and one from a fund, hedge fund or another fund, and gets over the $47,000, is that okay, or does it have to be from one employer?
It's a great question. And the answer is each employer, if they're truly separate, would be considered separately.
This is something where you may want to, again, the employee and the employer can agree over who the employer is. And so where you have a situation like this, so, you know, just in the funds industry, you have a bunch of entities, you know, and so the fund may be paying a certain amount out of a management company or from some other company, and then employees may receive some other amount from a different entity. But if you define the employer to include all those entities in an employment agreement, it's typically done this way in the funds industry, then you can look at all the compensation coming from the collective employer for purposes of meeting the minimum test. So here's one where the answer to the question is may depend on what your agreement says, so you can control the answer here.
And that's correct. And the DOL has also taken a very expansive view on joint employment relationships, and so they're probably receptive to the idea of accumulating employers if they are truly related.
Yeah, now, just one other word on that. Like most things in life, there's pros and cons. So if you're a joint employer, if both entities are the employer, then they're the employer for all purposes. And so, the fund then could be sued for discrimination along with the management company, let's say, in that setting. So all the employers would be subject to the typical risks that employers have vis-a-vis their employees if you make them all the employer. So that's, now, the fact is if they're both paying that employee, that might be a risk that already exists, and that making it clear that they're a joint employer isn't really changing the risk very much. It depends on the circumstances. I'm just making the point that, you probably want to take a look at it and determine whether or not collectively it makes sense and is valuable enough to you to make it clear in the employment agreement or in the offer letter, whatever, to make sure that it's clear that that all compensation from those sources is going to be counted together to meet the minimum requirement. I think one more, Chris.
One more.
This one.
Is it fair to say that low-level inside sales professionals may fall under the administrative exemption? I would say that's probably doubtful. So for the administrative exemption, the true administrative exemption, the employee has to exercise discretion and independent judgment with respect to matters of significance. The description of a low-level inside sales professional seems unlikely. There is an inside sales exemption that might cover certain retail employees, but you'd want to look at that exemption instead of administrative.
As everybody mentioned, when you're looking at these exemptions, it's very, very fact-based and very specific. Somebody who might be a low-level inside sales employee at company A might be exempt there, but if they're doing something different with the same job title at company B, it might be different. Job titles alone don't tell us whether somebody's exempt or not.
And, as you're analyzing it, if it's important to you to meet the exemption, then there are ways to change the duties that an employee does in a way where it's possible to meet the exemption. And, in some cases, there's a question of whether a duty is a primary duty versus a non-primary duty, or a significant duty versus a non-significant duty. And so you can make changes if you're willing to do that in the context of your business to the duties that are actually performed, not just the job description, as Lee said, but the duties that are actually performed, and turn what would be a non-exempt employee into an exempt employee. I think that's all the questions. Thank you, everybody, for participating. We had a really good group, and hopefully this was helpful to you. And you're welcome to contact any of us if you have any questions, any follow-up questions you didn't think to ask today. We're available, and you're welcome to give us a call. Thanks very much.